What you know, Alibiers? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It's Sunday, February 16th. We're going to finish up the latest in the Donna Adelson case. Just a reminder, Donna's next hearing is on February 26th at 9 a.m. Eastern. She will be transported for that. This is for the motion to suppress, as well as the motion to set bond and the Arthur hearing. After that, May 16th is set aside for pretrial motions, and we are still set for trial June 3rd. Donna had a hearing last Tuesday. Her defense team is asking to redepose 3 witnesses that they say were previously deposed by Donna's former attorneys. Those 3 are Chris Corbett. He does digital forensics like cell tower information. The next is Special Agent Patrick Sanford with the FBI. And then Robert Adelson, who is Donna's son. Donna's attorney told the judge they've been working to schedule depositions with the state, and this morning, for the first time, they learned the state does object to them redeposing 3 of the state's witnesses. The judge said he would need to read the basis of the request by the defense before ruling. Prosecutor Duggan said that Sergeant Corbett is just changing the format of the look of his presentation for trial, but if he did add any new information that the defense did not know about before, they would be okay with him being deposed only on that information, but not to repeat hours and hours of previous testimony. The judge said what he is not fine with is moving this trial date, and as of now, they'll keep that April 30th discovery deadline in place. If it needs to be moved up, it will, but he points out there's still 2.5 months before they get to that point. Let's read the filing of the motion to suppress portions of a recorded phone call. The phone call in question is the hot mic call that essentially got Donna arrested. I will link that phone call in the description below if you haven't heard it. I'm thinking about trying to improve the audio after the call drops. Don't know if I'll get that done today, but if I do, I'll post it and let you guys know. On November 15th, 2023, Mrs. Adelson was indicted for first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. One piece of evidence the state intends to use against Mrs. Adelson is a recording made after a jail call ended on November 7th, 2023. The call was originally made by Mrs. Adelson's son, Charlie, to Mrs. Adelson while he was incarcerated in the Leon County Detention Center. Although the call was dropped on the jail side of the call about 8 minutes into the call, the open line continued to be recorded. By this motion, Mrs. Adelson requests the court suppress the recording after the jail side of the call terminated and exclude it from the trial and any hearings in this case. The state has the burden to establish exceptions for warrantless interception of the terminated jail call. They go on to the statement of relevant facts. On November 6, 2023, Charles Adelson was convicted of first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. He had been held without bond at the Leon County Detention Center since his arrest on April 21st, 2022. On November 7th, 2023, Charles Adelson called his mother, Mrs. Adelson, from the jail. The recording of the call is 25 minutes and 29 seconds in length. At the beginning of the call, an automated voice notifies the recipient of the call that the call will be recorded and it's not a private call. The recipient of the call is required to acknowledge the call will be recorded prior to speaking with the incarcerated individual. At 8 minutes and 5 seconds in the call, Mrs. Adelson realized that Charles Adelson is no longer on the phone. At that point, Mrs. Adelson reasonably believed the call had ended and she puts the phone down. At the time of the call, Mrs. Adelson was present in her home with her husband, attorney Susan Brotman, and Miss Brotman's husband, Richard. After Charles's end of the call dropped, continued speaking with Mrs. Brotman and her husband, as well as Donna's husband. At the time of this call, no law enforcement agency had obtained a wiretap pursuant to Florida law authorizing the interception of Mrs. Adelson's oral or wire communications. They move on to the discussion of law. It goes without saying that inmates have a diminished expectation of privacy and, aside from calls with attorneys, their calls can be recorded. The same is true for anyone who accepts a call from an inmate for the duration of that telephone call. The legislature enacted the Florida Security of Communications Act, Chapter 934, Florida Statutes. The stated legislative purpose of Chapter 934 is to define the circumstances and conditions under which the interception of such communications and the use of the contents thereof in evidence in courts and administrative procedure. Oral communication is defined as any oral communication uttered by a person exhibiting an expectation that such communication is not subject to interception under circumstances justifying such expectation. Wire communication is defined as an oral transfer made in whole or in part through the use of facilities for the transmission of communications by the aid of wire, cable, or other like communication. It is well established under Florida law that for an oral conversation to be protected under Florida law, there must be both a subjective, reasonable expectation of privacy as well as an objective, reasonable expectation of privacy that society is ready to recognize. It is also well established under Florida law that when an individual loses that reasonable expectation of privacy, when they commit criminal or otherwise unlawful acts. They cite a case where a murder defendant didn't have a reasonable expectation of privacy that society was ready to recognize in secret recordings made by his victim that ultimately audio recorded the defendant murdering the victim. To determine whether the person had a reasonable expectation of privacy, which society is ready to recognize, courts will look at the circumstances of the communication, including, but not limited to, the manner in which the oral communication is made and the kind of communication and the location in which the conversation or communication occurs. For example, conversations which take place in public where a driver is speaking with two people outside of his vehicle is not an oral communication under the statute because the driver could not have had a subjective expectation of privacy, which society is prepared to recognize as reasonable. However, communications which take place in one's home are protected by Chapter 934 Florida statutes. Most jurisprudence the undersigned has identified discusses the inmate's limited privacy rights and the consent to the call being recorded given when the recipient of the call acknowledges the call will be recorded. Although Mrs. Adelson consented to the telephone call being recorded when she received the call from her son, what was the scope of her consent? They cite Davis versus State, stating that where a search is based on consent, the court must determine whether the search was conducted within the limits of the consent given. The United States Supreme Court has held that the standard for measuring the scope of a suspect's consent under the Fourth Amendment is that of objective reasonableness. What would the typical reasonable person have understood by giving consent? The scope of consent must also be considered in light of the consenting person's expectation of privacy. They cite case law which says we cannot agree that the state and its agents, by receiving an ill-defined or limited consent to be searched suddenly, are vested with all the authority conferred by a warrant. Such a holding effectively would vitiate the entire theory upon which the consent search rests. Where a communication is unlawfully intercepted, Florida law contains its own exclusionary rule that provides as follows. Whenever any wire or oral communication has been intercepted, no part of the contents of such communication and no evidence derived therefrom may be received in evidence in any trial, hearing, or other proceeding in or before any court, grand jury, department, officer, agency, regulatory body, legislative committee, or the authority of the state, or a political subdivision thereof, if the disclosure of that information would be in violation of this chapter. The prohibition of use as evidence provided in this section does not apply in cases of prosecution for criminal interception in violation of the provisions of this chapter. Mrs. Adelson's conversation after in her home was an oral communication protected by Chapter 934 after her son was disconnected. The question here is whether the consent of the recipient of the call gives for the call to be recorded terminates when the inmate side of the call ends. Typically, when two people are on the phone having a conversation where at least one of the parties is using a cell phone and one end of the call drops, the call terminates. Certainly, one can consent to their communication being intercepted by accepting a call from an inmate. However, that consent must necessarily be limited to consent to record the wire communication between the inmate caller and the one who consents to the wire communication being recorded. Once the inmate side of the call ceases to function, the inmate is no longer on the call, and the recipient of the call believes the call is over. The recipient's consent for the call to be recorded also must terminate. That must be true unless law enforcement received authorization pursuant to Chapter 934 Florida statutes, which was not done in this case. They say that pursuant to Section 934.06 Florida statutes, since the communication was unlawfully intercepted, it must be suppressed regardless of any good faith exception. In State versus Garcia, the court expressly held that the exclusionary rule is statutorily mandated and that Chapter 934 unequivocally expresses the legislature's desire to suppress evidence obtained in violation of that chapter. They finish by saying, wherefore defendant Donna S. Adelson requests that this court grant this motion, suppress the portion of the jail call after Charles Adelson was disconnected, and for such other and further relief as is just and proper. So that was it for that filing. And again, this is going to be heard on February 26th at 9 a.m. I will live stream that herein for you, and then I'll update you later that night. If anything new comes out of Donna's world, I'll keep you posted, but that's it for now. Hope you guys have a good rest of your evening, and we will see you soon.